Thank you so much. This webinar really focuses on the matter of community land registration in Kenya. As you might all know, in 2016, Kenya passed a quite progressive law that enables communities to not only document their claim over land, but also provides way for communities to strengthen tenure, to strengthen governance, and how they will rely on their land, not only as a resource, but as an identity aspect. Many communities to date have been able to register their lands using the Community Land Act. This study was exploring across the communities that have either registered or are in the process of registration, what does registration implicate with regards to pastoral livelihoods? Is it improving? What are the outcomes? What are the impacts of registration on pastoralist livelihoods? This is also relevant because about 80% of community land in Kenya is held by pastoral communities. That's a brief background of the study and why it was undertaken. At that juncture, I would like to invite my colleague, Aileen, and the team at Namati, who will introduce themselves, and then we'll listen in from the first speakers. The first speaker, who in this case will be Aileen. So I'll be calling out your name, and then you introduce yourself briefly to the audience. So we'll start with Aileen.
Hi, good afternoon or good morning, depending on where you're joining us from. My name is Aileen Wakesho, and I work with Namati. I'm joining from Nairobi.
Thank you so much, Aileen. Nuria?
Hello, everyone. My name is Nuria Salim. I work for the Grassroots Justice Network, which is convened by Namati, and I'm based in Nairobi.
Thank you so much, Nuria. We have Derek Mahandia.
Hello, thank you very much, David. My name is Derek Mahandia, and I work together with David and Wakesho at the Land, Environment, and Climate Program. Thank you.
Thank you so much. Ruth Okara.
Hi, everyone. My name is Ruth. I also work in the LEC department in Namati. Thank you for joining.
Thank you, Ruth. We have Soila. Jennifer. All right, looks like Soila is struggling with connection. I hereby invite our partners who worked with us on this study. So I will start with Dr. Let me make sure someone is here before I call their name. Dr. Hussein Wario.
Hello, everyone. My name is Hussein Wario. I'm the Executive Director for Center for Research and Development in Drylands. We are based in Marsabit.
Thank you so much, Wario. I here invite some representative from Impact Kenya. I think I saw Lawrence on the call. Lawrence, are you able to say something?
Hi, everyone. My name is Elmatarin Liyopoko. I work for Impact Trust in the Lands Program.
Thank you, Lawrence. We have pastoralist women for health and education who participated in this in the study. Golompo Dokata.
Hi, everyone. I'm Golompo. I'm joining you from Isiolo. I represent an organization called Pastoralist Women for Health and Education.
Thank you. Finally, someone from ESEED. ESEED also partnered in the study.
Dida will be joining in a bit, so we can ask him to join. He's having network issues.
All right. Thank you. Quickly, that is the team that was behind the study. As you might see, it was a collaborative effort across 5 organizations: Namati, CRDD, PWHE, ESEED, and Impact. We are all excited to be sharing these findings with you. Let me now invite my colleague Aileen, who will provide a general overview of the findings and the implications on pastoral livelihoods. Thank you.
Thank you very much, David, and good afternoon, everyone, once more. I had introduced myself, Aileen Wakesho, and I work with Namati. I am so glad to see very many familiar faces, not faces, but names on the webinar. So glad that a number of you could join in and follow through the conversation. Now, David started us off by just highlighting the fact that we did pass a Community Land Act in 2016. And this act provided a framework for recognition, registration, and therefore, protection of customary land rights. Now, like any other registration process, registration comes with a delineation of boundaries, as you do registration. Fairly a progressive law because for many years, community lands were seen as, lands that are owned by no one. If you look at the history of trust lands that were held by the defunct county councils, they were largely, really abused when they were under the custody of the defunct county councils. Now, registration of community lands then gives these lands equal status to other lands, including private land, and accords them the protection against, land grabs, and, equal compensation when it comes to acquisitions and so on and so forth. So you'd agree with me, this has been, fairly a progressive law. But even with this progressiveness, we acknowledge the fact that as David said, most of these lands are home to pastoral communities. And pastoral survival does depend on shared resources. Key of these shared resources are water points, grazing areas, grazing corridors. And these shared resources, in many instances, don't fit exactly in surveyed boundaries. What ideally that means is my community, which is community A, in many cases would have access to community B for purposes of either water point or grazing areas. Now, once registration happens, it comes with clear boundaries. And for those that know, of the things that a title gives you is rights of exclusion to a certain extent. So today, the big question that we're asking ourselves is, what does community land registration really mean for pastoralists and pastoralism? Because once you introduce boundaries where aspects of shared resources existed, does this bring an element of limitations? And as we ask that question, this particular research that David has highlighted was done by 5 partners, is trying to see, does this registration really cause a sense of tension as when it comes to shared resources? And how can we ensure that as we support communities to secure their tenure rights through registration, that this effort goes hand in hand with securing and safeguarding mobility and resource sharing across communities and across counties where that is needed? Because without that shared mobility, shared access to resources, then pastoralism is strained. And I think our quest as we support communities through the registration process is that this resilient, land use and livelihood, which is pastoralism, is not interfered with by registration, but rather registration enhances pastoralism as a key livelihood and as a livelihood that supports, many households and as a key contributor to the GDP. And so I invite us today to engage. We will hear from those that led this research from the institutions that we've mentioned. And equally, if time allows, from, some people who participated in the research in one or another. And my hope is that we will engage, and together, at the end of the conversation, we will all work towards ensuring that we strengthen rather than undermine pastoralism as a way of life, even through this registration process. Thank you, David, and thank you, everyone. Looking forward to all the discussions on this webinar. Thank you.
Thank you so much, Aileen. That's really helpful to give the basis and the background of the study. Now, I want us to listen in from the principal researcher, I will call him, the person that was behind the design and the data collection, who was coordinating the 5 partners. I hereby invite Porter. Porter will run us through the key findings and the implications of the findings. Thank you so much.
Thanks, David, and hi, everyone. My name is Porter. I'm a Bernstein Fellow from the Shell Center for International Human Rights at Yale Law School, and I've been lucky to work with the team at Namati for the past couple of years and all of the partners involved in this study. I hope you can all see the slides David is sharing. David, if you could go ahead and move to the next slide. So I'm very happy to present the findings from our study, which are explained in detail in the report that you can see here on your screen. It's published on Namati's website. I think my colleague Nuria has dropped a link in the chat so you can download a copy. In the interest of time, so that we can have time for some questions and discussion, I'll move fairly quickly through the findings. So if anything we say is surprising to you or you're curious about the evidence that guided us to a particular conclusion, I really encourage you to check out the report. We tried in the second section especially to quote directly from study participants as much as possible, so you can read people's perspectives for yourself and see whether you agree or not with our interpretations. And as David has said, the webinar is also being recorded, so don't worry about taking notes, but you should feel free to ask questions in the chat as we go along. So we got a great introduction from David and Wakesho, but just to concretize it a bit for this study, this picture was taken in one of the community lands discussed in this study in Shumai in Laikipia with three others, Ulpus, Nkaroni, and Iltirimin, visible in the center, off in the distance. And in between them are grazing areas in the Barsilinga area, as well as some other communities not included in the study, like Olduniro and Kipsing, that are at various stages of the registration process. So the picture is meant to highlight the questions about interconnection and sharing and about borders that prompted this study. So in the landscape you see in this photo, people move every day. They move for pastoral production. They move to access pasture, water, salt licks, maybe veterinary care, and they move for resources they use for their household, for commercial uses. They move to conduct business, for weddings, for funerals, for cultural reasons, and many more. The movements that I'm describing are regulated by a diverse set of systems and institutions. The communities in these areas have councils of elders, they have maybe mazingira committees, water resource user associations, community forest associations, wildlife conservancies, and political and security authorities like chiefs or nyumbakumi. And so movements in this study cross under a variety of authorities and also a number of borders. The areas you see span 3 counties and now some 6 or 7 community lands, both registered and unregistered. So as Wakesho already introduced, the question now is, as you start layering registration onto the systems, social structures, ecosystems that you see in this picture, how, if at all, does that affect the movements of people? And for us, we were specifically focused on livestock mobility and the movements of pastoralists. We want to know how registration affects resource sharing, and if such changes are happening, who's benefiting and who might be losing out, who's in need of reform to make the process better. If you can go to the next slide. As we wait for the next slide, concretely what we did for this study was we grouped the study we selected clusters of neighboring communities in 4 counties, Laikipia, Marsabit, Isiolo, and Samburu, that have historically shared access to important resources. Maybe they share a borehole, maybe they share a prime grazing area, like Barcilinga or the floodplains of the Owasso-Nyiro River. And we also selected a mix of registered communities. The 6 in Laikipia and Samburu are registered and have gotten title deeds, whereas the 8 in Isiolo and Marsabit are unregistered and have taken differing numbers of steps towards registration. And then last year, between August and November, we visited the communities. We held focus groups with community leaders, with women, with young people, and we also visited resource points, grazing areas, forest settlements, water points, to hear from people directly engaged in using the land to raise livestock. In total, we talked to 364 people, and we also spoke to county and national level duty bearers and conducted a desk review of relevant law and standards. So moving to the next slide, what we found in brief was that registration is a very powerful tool. It's a rights-affirming step under a progressive law that's a step forward for communities, but it has complicated interactions with existing pastoral systems, some of which could undermine pastoral mobility and, as a result, pastoral livelihoods. So the call to action, in our view, is to take further steps towards a pro-pastoralist implementation of the CLA, one that maximizes the benefits of tenure security with as few costs as possible to livestock mobility and reciprocity. And I'll say at the outset that the conclusions are prospective, they're forward-looking, and are based on a case study approach, not a rigorous academic study, because of the diversity of the communities we visited and time and resource constraints and just the general newness of community land in Kenya. We were never aiming for a definitive yes or no answer to whether registration is undermining mobility or resource sharing. We're hoping rather to share just some nuanced perspectives on emerging trends and to suggest areas for further study and possible reform. So with that in mind, I'll run through a group of our key takeaways, and then I'll say a bit about each one. So the first you can see on the screen is that community land registration is popular. Most of the people we talk to support registration, but they have different ideas about whether and how registration will affect their mobility. Second, as it is now, registration, both in the law and in practice, seems to place too much emphasis on communities' ability to regulate or exclude non-members. And then the third and related finding is that to date, registration has not formalized the access or user rights that pastoralists establish via negotiation or reciprocity or seasonality, even though those rights are recognized under customary law. The fourth finding is that, generally speaking, mapping processes required by registration, whether sketch mapping or survey, tend to rely heavily on administrative borders and don't give enough attention to community-defined and agreed boundaries. The fifth finding is that despite a lot of work and safeguarding by NGOs and other stakeholders, registration remains an elite-driven process where communities are using representative models to make rules and decisions on behalf of resource users rather than directly including all parties in all of the decisions. The sixth and then the seventh finding are related. The sixth being that the rules and institutions, so the community bylaws, the Community Land Management Committee, and the Community Assembly that are being formed by communities are still quite new and have varying degrees of operability, and that further study of these categories, registration, land, livelihoods, is essential and should be ongoing and multidisciplinary. So the other thing I'll add before we get into each of the findings in more detail is just an idea of the world we would like to see coming out of this study. So things that seem important to us are more public education, using a lot of different modes of reaching mobile people, going on the radio, using digital technologies, also going to print media. David, if you could just click so they come up on the screen. But we personally think some formalization in some form, whether in bylaws or during adjudication of user rights, would be a useful step for communities. We'd like to see more financial and technical support to communities and their partners during and after registration. We'd like to see bylaws that are joint between communities and their neighbors, communities and people that come from even far distances to use their resources. And again, we'd like to see many, many further and related studies from all of you and your partners and others in this space. Sawa sawa. So I'll now take 15 minutes or so to go through each of those 7 key findings in a bit more detail and point you to things in the report that can give more information. So the first, as I said, is that registration is very widely supported. Of the 360 some people that we spoke to, probably 90% supported registration. And of the other 10% who were more skeptical, many changed their opinions mid-interview as they got more information about registration, which was an unfamiliar topic. And the study found very good reasons for that popularity. The first, as Wakesho said, was defense against land grabbing, feeling more secure in your community's tenure rights. And second, more inclusive land and resource governance. In the former group branches, especially in Laikipia and Samburu, adding women, girls, and young people into the registers of members, the recognized owners of that community's land, is a very tangible improvement in the management and sharing of resources in those areas. And in some cases, opportunities even exist to reclaim previously privatized land. So Nkaroni and Lupus in Samburu are good examples here, where the communities, as part of registration, are working to convert parcels that had been either legitimately or illegitimately converted to private ownership back into community land. These would be big wins for the community. I think by a rough estimate, it would expand the recognized grazing area in Lupus by 15 to 20% if the land is reconverted. So on the next slide, you'll see that when it comes to mobility, though, we found a lot of divergent opinions, a lot of disagreements about what has happened to date and what will happen in the future. So first, in Laikipia and Samburu, we tended to hear about improvements in land management that reduce the need for mobility, as you see in this quote from Moropusi. We also heard about reductions in herd size that make it such that the traditional mobility practices are less necessary. So the herders that you see kind of behind the text on the right, for example, told us in Shulmai that since they're keeping only 10 to 20 heads of cattle, this new approach is easier, of more intensively managing a smaller land area within the community land borders. They thought that people with large herds of maybe 100 heads of cattle or more would be disadvantaged, but that doesn't really apply to them in their situation. So then on the right, what you can see is from Isiolo and Marsabit, we heard more skepticism of registration as a potential restriction on individual herders' choices. People in Chari and Cherap, for instance, in Isiolo, do not like the idea of those very interconnected ecosystems being registered as separate units, and the CLMC members and other stakeholders in those communities have emphasized that registration will impact the oneness and interconnectedness of those communities. Although to some extent, some of the opinions we heard in these areas are also somewhat self-contradictory, because despite people's fear of losing access to resources outside of their community land, they also want greater authority to exclude outsiders, like people coming from Marsabit to Waso, as you can see at the end of the second quote. So it's a complex picture, and much further study is needed to understand whether land management can actually reduce herders' long-term need for intercommunal mobility the way it was traditionally practiced, whether community land registration can really strengthen communities' exclusion rights, and if those two trends materialize, what that means for pastoral production and for livelihoods. So we'll go now to the second finding, which is, as I said, about an overemphasis in law and in fact on rights of ownership and exclusion. So David, if you'll go to the next slide, there's a quote from Women in Tirimine, which it highlights a balance between a desire for greater control, using registration to protect resource availability at home and to ensure rule following by members and non-members, a balancing of that against the need for reciprocity and the protection of people's access to neighbors' resources in times of need. It's a balancing act, and almost no one we spoke to viewed registration as entirely cutting off these relationships. Which is how actually, in my view, the Community Land Act and regulations treat the issue too. They focus on tenure rights of communities, but they acknowledge the grazing rights of non-members, albeit subject to community regulations. So David, if you go to the next slide, in terms though of how communities are attempting to strike that balance, it was clear in our study that much more weight is being given to control of outsiders and potentially the commercialization of resources, or the strengthening of communities' claims to disputed areas, than it is to things like livestock corridors, livestock mobility, reciprocal rights. So if you look at some of the quotes on the screen, you can see some of the expectations that we heard for registration and its effect on non-members, its effect on outsiders. For now, these are expectations. It's very early stages, especially in Marsabit and Isiolo, where communities aren't registered yet. It's an open question, sort of like whether the Chari community, for instance, whether claims to calm will actually be impacted by registration. But given the potential implications for herders' access to particular areas, it's worth noting from the point of view of our study that this is kind of where the existing association with registration and where the emphasis is currently placed. So the sort of paired finding from our study is that to date, registration is not formalizing user and access rights that are established through negotiation or through reciprocity, even though pastoral systems do recognize those rights and community members and herders know about them and claim them when they move outside of their community. From our point of view, this is a missed opportunity. The law provides tools where these rights, which are recognized under customary law, could be formally registered, whether through CLA Forms 9 and 10, in community bylaws, or as part of adjudication. But none of the communities in the study area, and to our knowledge in Kenya, are making use of those available tools. So one way of thinking about it is that pastoralists are essentially leaving a significant chunk of their recognized property rights unsecured. And they seem to be doing so for many reasons. One reason is just confidence in the vastness of their community land and the richness of their resources. Another thing we heard a lot was that the social ties between communities and their neighbors are so strong that community members just didn't think anything like even registration would really impact sharing or reciprocal rights between communities. And then another contributing factor is just resources and public education and a lack of awareness of the available tools. But from our perspective, leaving access rights as undocumented and customary while ownership rights get formalized is a risk that pastoralist communities and duty bearers are taking, and it's one that needs more attention and study in the future. So the fourth finding is about mapping. The registration process requires mapping in several ways. It requires communities to make sketch maps and then national government to adjudicate and survey community land. And on the whole, this one is quite difficult to summarize given the sensitivity of border disputes and the diversity among communities. But on the whole, there is a push to some extent from communities, but especially from duty bearers to resolve border disputes by replacing general or zonal borders with fixed linear boundaries established through ground-based surveys and recorded in cadastral maps. And the boundaries that are being used for those decisions are administrative or political boundaries, like ward or location level boundaries, or maybe IEBC constituencies in some cases. That decision has a lot of implications. It has cost implications. Ground-based surveys are really expensive. It has resource implications. Most community land units, as Waukesha said, don't contain all of the resources that members access in a given year. And it potentially also has governance implications when you align registered communities with pre-existing political units that have elected representatives serving in government. We don't know yet how that choice will affect decision-making power over land and natural resources. So our preference in this study would be for registration to proceed based as heavily as possible on communities' self-defined and mutually agreed boundaries, even or perhaps especially if those differ from political units. And I'd love actually for us to hear later in the webinar from our friends in Kina, Kulamawe, Gotu, Deda community land about how they approached and thought about these questions. For now, though, we'll move on to the fifth finding, which is about the use of elites and the fact that despite a lot of good work on safeguarding the rights of minorities and participation by the whole community, registration is somewhat inherently an elite-driven process where communities who have limited resources and need to meet and make decisions across really large land areas end up relying on representative decision-making rather than direct participation by all affected people. And many of the participants in this study told us that that rule came from registration. But when you look at the bylaws of those communities, the Laleta rule actually was not codified in the community's adopted rules and regulations. And in interviews, leaders couldn't remember whether the rule came from bylaws drafting, from conservancies, or from somewhere else. So while registration is associated with this pretty significant constraint on herders' movement in these communities, the actual causal chain requires further study. So now, David, we can go to the next point, which is also about the bylaws. And just to say a bit more generally that in this study, community leaders that we speak about the bylaws, describing them as helpful sort of codifications or protections of traditional systems that will hopefully revitalize elders' authority to enforce the relevant rules of systems like Anata and Kop or Deda. And there's some evidence, as you can see from Mayanat, of good and inclusive rulemaking happening in registered communities where bylaws are taking effect. But David, if you go to the next slide, when you look actually at the written community constitutions of these areas, we found that the written bylaws don't draw actually that heavily, or in some cases really at all, on the traditional laws. Instead, they are very, very heavily based on the model rules and regulations that come in the third schedule of the community land regulations. So this provision from Schulmai is one example. The only time they talk about customary law is in a provision that comes from the model rules and recognizes traditional law just to the extent that it's compatible with the operations of the community. And an additional note is that all of the community's bylaws that we looked at are written in English, pretty complicated English, which most community members have little way to access or understand, and none of the communities have translated their written bylaws into local languages. And you see on the right some of the reasons and the reasons behind and effects of that choice. So our view from this study, since those rules are so important to people's day-to-day use of resources and the overall health of pastoral systems, is that much more work is needed to draft and operationalize the bylaws in ways that reinforce and improve traditional systems. And I know CRDD, PWHE, and ESEED have all worked on written codifications of the data systems, so I hope we'll hear more from them on that shortly. So finally, and in summary, the last finding, as I've said several times now, is that registration does clearly have effects on pastoral production systems, on resource sharing, on mobility, and fairly few of those possible, real, actual or possible effects are well understood. So we need many detailed studies pulling from various, yeah, David, you can go to the seventh slide, the finding 7. We need a lot of studies, and they should be interdisciplinary. They should incorporate academic disciplines, indigenous knowledge systems, of how to get community land registration right and maximize the benefits of this powerful legal tool. So we can go to the last slide just to say that's all from me, and thank you very, very much to the wide research team of people who contributed their time and talents to this study. There are too many to picture, but if you go to the first or second page, I think, of the report, you'll see the full list of people, and we're very grateful to them. So thank you, everyone, and I'll turn it back to you, David, to go to the next session.
Thank you so much, Porter, for running us through the findings and the implications. We had other partners who were involved, and so I'd like to give at least a minute to each of the representatives to say something that they picked from the study and would like to share with us. I'll start with Dr. Wario. Dr. Wario, karibu.
Thank you so much, Porter. That was quite aptly presented, and there isn't a lot to add, but rather, looking at this study, there are things that really speak to us, in the sense that despite all these years after the law has been passed, a lot of the issues that are spoken about by the communities are based on their limited understanding of the law itself. And, understanding of the law and using it is the primary thing that the communities need to have. And that gap is one thing that influences some of the views that we have seen. And also that also limits the communities in terms of adapting the law, to their context. A lot of time people try and, use this law the way it is without really reflecting and seeing. But in some circumstances, like, for example, in use of the traditional, bylaws, in strengthening resource governance, some communities are using it to strengthen what they already have. And on the other hand, of course, conceptions of borders is something that affects how communities conceive this law. And borders are quite colonial in origin, and already communities have a lot of troubles with administrative borders. And in a way, when people look at this law, some want to use it as a way to kind of legitimize, some claims that they have had on land, rather than looking at it as a mechanism of, ensuring their children rights are protected. And at the same time, communities also overlook the fact that beyond ownership of the, land, other user rights, seasonal user rights are equally protected within this law. And that is also comes from the misconception. And the other disconnect that brings about some of these issues is the fact that the law is an intent. It is to protect, customary tenure rights. Customary tenure rights, the custodians of customary tenure rights are, the customary resource use institutions. The law doesn't really emphasize on this. Rather, the element around this elite influence comes from the fact that, the law brings about use of elections, to bring about the community land management committees. And so that influence of the customary institutions is disconnected from the customary tenure rights that the law wants to protect. And I think above all, our study here was conceived based on the fact that mobility remains the key strategic adaptive use, land use by pastoralist communities. And if that is compromised, then the whole system will be compromised. Because of the misconceptions around mobility also, you will see that technical people who are supporting the communities to understand the law and register their land do not give this focus of mobility being central. And the misconceptions around mobility is what people use to influence, in a way, the communities to think about these rigid borders and, controlling access. And, in some ways, people will say, oh, you can use this land to even get loans as collateral to advance, other economic objectives. So this kind of presentation of the law also is a limitation. Sorry, David, I might have taken a bit longer, but these are the things that talks to this study from the background. So thank you.
Thank you so much, Daktari. That's very insightful. I would also like to invite our friend Dida from ECID. You want to say a word to the study? I saw that you joined. Okay, if we can't hear from Dida, I'll welcome Bwana Golompo from PWHE, who participated in the study. I would like to, in case you'd like to say a word.
Okay, thank you very much, David. I would like to say something on mobility.
David, I'm there.
Okay, Dida, you'll share after Golompo. Thank you.
Okay, thank you.
Okay, I would like to say something on mobility. Pastoralism traditionally uses land as uses land by the community, often with the seasonal grazing pattern, which for our case, leather. Translating this into flexible system, or translating this flexible traditional system of leather into this formal registration could be very difficult. Then I would like also to say something on mobility versus the boundaries. So the leather system depends on mobility and shared grazing across the landscapes. Once this land is registered with the fixed boundaries, pastoral access to the dry seasons grazing area, I think also will be compromised. Same to the migratory routes. Because of the fixed borders, I think there will be some restrictions that could be made to these migratory routes by the communities, and denying the user rights for others. Also, I think there is pressure from external actors, investors in the community land, the government projects, like the mega development project that's going on in Isiolo, the conservation initiatives that are already existing, and others also coming up. Then we also have some extractive industries that are also coming up within the community land landscape. Many of these, I think there's some general fear that the risk is displacement if there's no enough safeguards in the community land. Having said that also, but we have also some opportunities as far as the legal recognition and protection is concerned. I think also the community land registration, it has brought in some elements of the protection and recognition of the community land tenure rights. Then another opportunity that sits with the community land registration is the diversification of livelihood for this pastoral community, because they can also venture in something like carbon credit, ecotourism, and also part of rangeland management. So I think those are some of the opportunities, some of the challenges that we observe from where we sit. Thank you, David.
Thank you so much, Bwana Golombo. Dida, you're welcome.
Well, thank you, David. Thank you, Porter, and the rest of the team. I think it's true we participated in this study, and this study is both relevant and anticipatory in the sense that we are not yet done with the full registration of all those lands that are unregistered community lands. And the findings are not also very peculiar because it just confirms some of those fears that we do have, either perceived or the existing ones. But the key things towards the questions that does the registration cause tension, I think this is quite an important question. But the key thing is that does it really cause, it's not about cause of the tension. The tension exists between communities because grazing systems had always tensions and it had also conflict. But the key thing that this registration causes is exacerbate these existing tensions. And this tension is also the cause of the slow pace of registration. Then the second thing, does it affect the resource sharing and mobility? I don't think so, because definitely these are some of the fears. But when the law says it recognizes customary use, if it is registered as a customary per se, it will promote more sharing than exclusive use. The same with protection and also registration, because even the registration, the title that comes is in community ownership form. And more importantly, this registration does not only stop at registration, because there's post-registration land use planning that will also enhance the application of the bylaws and the sharing arrangement and the migrations. To look at also the migration, I think the seasonal migration and also other kind of migrations, and most of it normally happens within the existing customary land use pattern. So if this mobility is within the customary use that is existing, then the issues of exclusion does not also arise. But it will just, registration will make better this seasonality of mobility for better use of the resources. And when it comes also the mobility across the border, the regulation provides or envisages these cross-border usages through negotiations and protection of special rights and entitlements. So looking the law as it is, if you understand the spirit that went into this community land registration model, the element of actually exclusion is a foreseen, and also protection against this is also inbuilt in the process. But some of the things that really causes this tension and fears around mobility and resource sharing is the missteps that we have taken as elites, which the study clearly brings it out. The elite point of view is that elites look at these things entirely from the legal and technical perspective. Once these now dominate the process, then the way the inventory was handled is one of the way. There was less participation by the users and the owners of the land. And then the administrative and consistency of electoral boundaries takes dominance, and there's also element of politicization that really creates the tension and missteps in the inventory making. Then when it comes to the community level also, I think communities, some of them did these activities in secrecy. And the election, of course, causes also politicization of the whole process, because once you start talking about election in a community, people will take it just like in the political elections. Then this information is also a little bit held in secrecy, because like the case of Marsabit, the inventory, though it is a public information up to now, it's, I think, it's restricted access mode. Nobody have access, even those of us who are participating do not have access to those inventory the way it was done, because there was actually less participation. And definitely there are many underlying issues, which already mentioned by Dr. Hussein, about the common understanding of the community land registration model and the law that guides it. So all these factors will contribute to the fears that we are having, but the study brought out those findings that we really expected some of these findings to come out the way it came out, because we've been interacting with communities, and the communities have been giving us feedback on all these fears that we are trying to investigate through this study. Thank you.
Thank you so much, Bonadida. I know we are already past time by a couple of minutes. I also note that we started slightly late. So I would request that we hang on for some additional 6 minutes. I will request our colleague from Impact to be as brief so we can open up. I've already seen a comment from Liz, and I would like the researchers to respond to it. So Lawrence, if you could do in a minute, so we open up to interactions for the last 5 minutes.
Okay, thank you, David and Porter. Just briefly, community land registration in northern Kenya is moving quite fast, and it is going or reshaping how people think about their lands. On the positive side, it has strengthened the tenure security, revised systems like the data in Isiolo and Yanatangop in Samburu and Laikipia, and created space for women, youths, and widows to participate in land governance. Communities also feel more capable of protecting themselves against land grabbing, and in some cases, they even reclaiming land that was lost in the past, as we realized in Karoni and Ripos. But these gains also come with some trade-offs. In some places, like as you mentioned, Samburu and Laikipia, new rules have emerged that restrict movements. Later, settlement by herders from outside. While such restrictions give communities more control, they also risk reducing mobility and straining the networks of that pastoralism has always depended on. And also what we found is that communities are using legislation to formalize ownership and exclusion rights, but very few have documented reciprocal access arrangements within their neighbors. So the key lesson is registration must go hand in hand with negotiation. These communities are registered and their partners or other communities from other areas. Because if we focus only on securing tenure rights without protecting shared access, we may unintentionally weaken the very pastoral system that kept rangelands over the years. Communities, governments, and partners need to strike a balance, strengthening security while also safeguarding the ecological and social interdependence that pastoralism livelihood depend on. Thank you. That is from my end.
Thank you so much. We already have 2 comments in the chat, and I would like to request the researchers to respond to this. Number 1 is a comment from Liz Wiley, who says that this is an excellent report. She would have loved to listen to more concrete recommendations, especially towards the duty bearers, the ministry, how to produce a draft regulation that will address these findings. We have a comment from Noor Ahmed, who says that since land issues affect all pastoralist communities, how can Northeastern, that's Mandera, Wajir, and Garissa counties benefit? So if you have any comments, feel free to add to the chat, but I will open up the questions now. Feel free to raise your hand, ask. I'll take some 3 questions and then I will hand over to the researchers to respond. Okay, for those 2, let me ask Porter if you have something to say, and then the other researchers can also chime in. Thank you.
Sure. I'll just briefly say first to Dr. Liz, thank you. That's excellent feedback. And on the second point you made about CLA forms 9 and 10, I agree with you that they were not designed for this purpose. They potentially could sort of be shoehorned into recognizing user rights, but as you said, the purpose of those forms was to register occupancy rights within community lands, which is a separate issue. So I agree with you that we sort of presented it as in the immediate term, maybe communities could try this to see. But I certainly agree that more attention to what a longer term fix for some of these issues looks like is a better solution. It's a great idea to work with the ministry and to do it in an iterative way with communities, because I think there are also a lot of questions about actually, given how many access and user rights are recognized under customary systems and how they can change based on season or based on changing political or social circumstances, like whether written forms that get submitted to the CLMC are the right way to protect those rights. And something I didn't get to say in the presentation was that we heard actually pretty often from people in group branches that leaving access and user rights, like leaving secondary reciprocal rights unregistered and informal, really doesn't impact their movements in their experience in the group branch era. And I think community land will be quite different. So it's not necessarily an assumption that we should just, since it was fine in the group branch era, it will continue to be fine. But I do personally think it's a very active question of what's the best way to double lock user and access rights in the same way that we're double locking ownership rights. And I'll also point people to the section of the report that deals with international best practices, because especially in West Africa, in other contexts, there's been more attention paid to registering different types of rights that pastoralists hold rather than just ownership and exclusion rights. And then, yeah, for the work with the proposal you make is great. And in general, I think we at Namati are really hoping this report will be a starting point. It will be anticipatory, as Dida said, and we can flesh out further recommendations and areas of further study as we go. And then for Noor's question about Northeastern, I think it's important. I'm not sure I'm the best place to speak to it. The only thing I would say was in this study area, has been important for partner organizations to facilitate learning between come a bit later. And so maybe for people in Northeastern to look at what's happened in Samburu, look at what's happened in Marsabit, and try to improve on the process as they go would be a good idea. I saw a hand, but now it has gone, so I'll just stop there.
Yeah, we had a hand from Luigi. Luigi, would you like to ask your question? Thank you.
Yes, if I can intervene briefly. I'm Luigi Luminari. I work with the National Drought Management Authority. I'm a technical advisor. And we have a lot of interest on this topic, also because very soon we'll start a new grant funded by the Italian Corporation that we try to support the 7 counties in land registration and also for the communities that have already developed, they've already acquired title deeds to help them to support land use planning, natural resource management, and so on. Now, my brief question is, you have targeted the Isiolo and other areas where there are many conservancies, and you have not mentioned about the impact of the conservancies on mobility, for example, how the biolaws of the conservancy has been mainstream within the land plans. And the other question is about there are some cases where community land is not clear. It is claimed by different ethnic groups. I don't know if you have come across such an issues and what kind of approach could be used in these particular cases. Thank you.
Thank you so much. I will add one that is currently in the chat area. Whether the study considered conversion from group representatives to community land. Victor says that there are groups that skipped the community land registration and with the endorsement from the registrars ended up going the subdivision way. Whether that is something the study considered or looked at. I'll pause there and then hand over to the researchers. Thank you.
Is there anyone else from the team that would like to answer any of those before I? If not, I can go ahead. Well, I'll just answer them briefly and hope someone will add their perspectives. So to go maybe in reverse order, on the issue of the group ranch, the conversion of group ranches into community land, that was not a central focus of the study, but if you look in the sections about the institutional landscape, in some of the communities it did come up, whether or not, how many of the CLMC members are former group ranch board members. It's a very important question, obviously, and something that deserves further study. I think it depends community to community. But I would say it's generally true, or something we heard a lot was that in Laikipia and Samburu, registration was more described using the word transition, like as just a technical transition from group ranch era to community land. And that's quite different than a really sort of open participatory process that's envisioned in the law. And it's different than what's happening in trust land areas where the registration unit, for instance, is quite unclear and requires a lot of debate to decide on what unit to register as a community. On the issue of overlapping claims between communities, Luigi's second question, I think it probably happened. I think some of the communities we discussed said they submitted expansive sketch maps and were just kind of waiting to hear back on what the end decision would be and how those maps were compared to those of their neighbors. And we didn't hear really any communities say that they sat down jointly with their neighbors and did maps that mutually agreed certain points. So in our view, that's a sort of dangerous approach, and it's something that requires careful management. If not, it can lead to conflicts, which obviously have devastating impacts on people's ability to move and share resources. So some of those issues are discussed in the mapping and dispute resolution sections of the report. And then finally, on the conservancy question, I don't think we didn't really look at how conservancies affect mobility itself. We looked more at the institutional landscape, and we're trying to understand how, in places where conservancy boards exist, how do CLMCs and conservancy boards overlap? How are they different? How are communities managing that? And with what effect for land users? So if you look again in like the CLMC section of the report, that's where you'll see, I think, the most about conservancies is in terms of decision-making and governance, more so than direct effects on mobility.
Thank you, Porter. I know we are already over time, and I'd like us to close.
Hello.
But I'll give.
Hello.
Yes, please.
My name is Sandra. I'm concerned about how the report has also incorporated the question of the RDSASA platform in the context of registration of community land, because I know that has been a challenge, and whether then the Ministry of Land has been, or rather the registration of community land has been integrated in the new land, the online land registration process. Whether it's something that has been factored in the report now that we are going digital in terms of registration of land.
Thank you. And I think the last one would be, there's a final comment from Dr. Liz Wiley. So if we can respond to those two, we should be able to close our webinar. We have 2 minutes to go. Thank you.
Yeah, thanks for these helpful interventions. Very quickly, I think RDSASA we didn't explicitly discuss, but it's quite relevant, and I'm happy you raised it. I think it speaks to different parts of the report. First, about public education and transparency. Can communities access and understand reliable information about what's happening with registration? I think going digital is a step forward in that area. And then secondly, again, a sort of more forward-looking dimension of the report is like these trends are quite complicated, and there might be people that are differentially impacted or even lose out from the registration process. And so the need for ongoing monitoring and study of community land as it functions as a living category in Kenyan land law will be important. And I don't personally know much about RDSASA, but I imagine it could be helpful there. And then on adjudication, I think that's an area of the report that there's a lot that's kind of open in some ways. Not a lot of adjudication of community land has been done. And so it's an area where we'd love to see collaboration between civil society and communities and duty bearers to really get that process right, because there are huge, huge differences between the adjudication of private land and community land. And there's a lot of room for improvement, I think, to the current plans. And as you pointed out, Dr. Liz, there's a lot of global best practice that can be helpful in Kenya. So thanks again, all.
All right. Thank you so much, Porter. Thank you, Dr. Wario. Thank you, Dida. Thank you, Lawrence. Thank you, Golompo. We thank you so much for the effort you put in to put together these lessons. I know there are additional questions coming in. I urge you to download the report, read it. I'm sure it will respond to some of the concerns you have. Porter went through the overview, but there's a lot of content, a lot of quotes that will be helpful in responding to some of those questions. That being said, I thank you all for agreeing to participate and attending this webinar. We've had about 50 people attend. It's exciting to see that people are interested in this subject matter. And I hope that we continue to deliberate on it and ensure that the communities in the North, the pastoral communities, leverage the Community Land Act to enable and propel their livelihoods. Thank you all. Yes, Dr. Wiley, I think it would be good to get in contact with you. We shall definitely do that. All right, feel free to exit